It is 4:23 on May 13th, 2023. This case I'm about to review is one I've seen before. I've not reviewed it until this time, although I've known about it for some time. If you could see the date here, April 30th, 1941 is how many years before April 30th, 2022? Right? Because what happened on May 1st of 2022? I made a public notice about that. I also made another public notice at the beginning of November, and I made a public notice at the beginning of this month, May, right? Specifically regarding what happened on May 1st of 2022. This bank is called T.R. Colbert, or is it Colbert, versus Dallas Joint Stock Land Bank of Dallas. Number one, evidence. Telephone conversation, witnesses. What does it say? For a telephone conversation to be admissible in evidence, there must be proof of the identity of the person with whom the witness talked. Such proof is usually afforded by the testimony of the witness to the effect that he recognized the voice of the person with whom he was talking. Wow. Okay. This was also, by the way, prior to the days of availability of common phone tapping or personal recording of telephone conversations. Am I correct? 2. Telephone conversation evidence. Telephone conversation may be admitted in evidence without proof of identity of person answering the call if such conversation is carried on over a business telephone maintained for business purposes and the person receiving the call represents himself to be the one called or assumes the authority to receive the message in the absence of positive proof to the contrary. 3. Interest, action, limitation. Limitation may bar a cause of action, but interest on a principal sum of money does not of itself constitute a cause of action, but is a mere incident to the principal sum, and its recovery is permitted in order that the injured party may be fully compensated, and the addition for a claim for interest, while enlarging the amount sought to be recovered, adds no new transaction and is not barred by limitation. 4. Quantum meruit, commissions. In a suit to recover on quantum meruit for services rendered, the law fixes the measure of recovery, implying a promise to pay the reasonable value for such service. In determining what is reasonable under the circumstances of a given case, the end accomplished as well as the time and effort expended should be taken into consideration. 5. Evidence, hearsay. Where it appears that there was no evidence to prove the authority of a vice president of a bank to employ a broker to sell land for the bank, a statement made by said vice president to a third party that he was going to turn the property over to said broker for sale was hearsay and should not be admitted in evidence. First of all, on reviewing the introduction describing the original case, the appeal, the Supreme Court's decision to remand to the district court for a new trial, the district court's determination, and then the appeal. What this shows is a sequence that looks very familiar, except it didn't happen in 1941. It happened before 1941, way before 1941, and it involved a case that did not occur in the United States. But it did involve a case regarding joint stock. For the record, what this says is that in the suit, the first trial of the case of judgment was rendered for the plaintiff, and that judgment was reversed by the Court of Civil Appeals, which rendered judgment for the bank. The Supreme Court reversed the Court of Civil Appeals and remanded the cause to the district court for a new trial, where judgment was again rendered for the plaintiff, and upon appeal was again reversed by the Court of Civil Appeals, which again rendered judgment for the bank. The case is once more before the Supreme Court on writ of error. For the record, at this time, in the state of Texas, writ of errors are not accepted by the court. There are other writs that must be presented before the court. However, in 1941, writs of error were permitted. Now, it also talks about an additional process here. I'm talking about referral to the Commission of Appeals, Section B, and the Supreme Court's adoption. Then it says judgments of both courts were reversed and the cause was remanded to district court for another trial. That means a third trial. Am I correct? Interestingly enough, what does this say? Mr. Presiding Judge Smedley in 1941. Okay, for clarification, it would seem to say that due to the request for a writ of error, that this isn't actually a third proceeding, but rather a consideration of error in the second proceeding. Okay, it talks about how the Court of Civil Appeals had 4 holdings in its judgment. However, there are notable things in here that I'm going to identify as caution. This was from April 30th of 1941, this specific judgment, but it discusses how it had been through the courts for a period of time subsequent to this particular determination. And among the things it says is a difference between the express contract for the full acreage versus the proof of partial performance for 1/2 interest, as well as the fact that he occupied the status of a volunteer and his contract of employment by Gay. In addition, it also identifies that there is no evidence to support the jury's finding that Colbert was the procuring cause of the sale of a 1/2 interest in the land to Carruthers. And the point being is partial performance involving 1/2 of what was promised. Also important here is what? Gay, Assistant Vice President of the Land Bank. Gay, authority from the Land Bank to employ a procurer to procure a purchaser for the ranch. Notice it says procure a purchaser for the ranch. Then it discusses 5% as the usual and customary agents commission for the sale of the land in the neighborhood of what? Stamford, Texas, in the spring and summer of 1933. What was going on with gas and oil law in the state of Texas in 1933? Okay, it also identifies that there had been 3 rulings of the Civil Court of Appeals, but then also cites that it was basing its determination of the procurement of a purchaser of the ranch and its relevance in support of action on quantum meru E on a case, Henrietta National Bank versus Barrett, 25 SW 456. It also says, very importantly, if valuable services were rendered by Colbert for the bank and the bank knowingly accepted them or the benefit of them, the value of such services may be recovered on quantum meru, even though the contract is unenforceable on account of Gay's want of authority to make it or for some other reason. Okay, now this pertains to matters that were actually discussed earlier today and have been coming up frequently in the last few days. It's important because there's another case in here regarding the Dallas Stock Land Bank that is dated for February 5th, which is what, relative to February 2nd and February 9th. But this is a quote from another case. Rogers, Hill and Company versus San Antonio Hotel Company. Saying, quote, the principle is well established that where one receives a benefit by accepting the services of another, even though performed in pursuance of an invalid or illegal contract, nevertheless such person is bound upon the plainest principles of equity for the reasonable value of such services. Now, this is very important. This has also come up recently in the context of international law. But let us identify, what have we already found in this case? Right? Including that the case reference regarding quote, performed in pursuance of an invalid or illegal contract, end quote. Okay, on page 272 of this court reporter, but on the consideration of within the first 4 pages of this case, it identifies the president of the land bank at the time. Remember, Gay is the vice president. The president is Ferguson. And the phone call of concern was to President Ferguson in connection with the determination of the proposition Gay had made regarding showing the land. Okay, so one of the things it discusses here is that the determination of whether or not the bank had been availed of services by Colbert, that it does not rest solely upon the proof of the sale of the undivided one-half interest, but upon that fact when considered in connection with testimony as to the conversation and somebody else's visit to the ranch and conversation between the two. So it's not just proof that there was the sale that was allowed to occur, but that there was some connection with the actors involved that had a knowing relationship to the transaction. Now, this is important because I said knowing. And what this is saying that, quote, according to Colbert's testimony, he showed Carruthers the ranch, began negotiations for the sale to him, and advised the land bank of his conversation with Gay and of his efforts to induce Carruthers to buy the ranch. And the land bank, a short time thereafter, took the matter into its own hands and availed itself of the fruits of Colbert's efforts by selling an undivided one-half interest in the land to Carruthers. There is in such facts basis for the reasonable inference that Colbert was the procuring cause of the sale. And then it cites Hancock versus Stacy. Okay, this is important in the first 2 areas identified here. The first one discussing whether or not there was testimony that the identity of the person with whom the witness talked was confirmed. And it says that the testimony of the witness that he recognized the voice of the person with whom he was conversed was not offered at this time. But it discusses how the rule requiring proof of identity is subject to the well-recognized exception that when a telephone call is made to a business office over a line maintained by it for business purposes, testimony as to a conversation with a person answering the telephone is admissible without further proof of his identity, the presumption being indulged that such person, if he represents that he is the one called, or if he assumes to have authority to receive the message, is the person called or does have such authority in the absence of proof to the contrary. And cites the cases and says, but Colbert's call to Ferguson is not shown to have been made to Ferguson's place of business or to the land bank's place of business. This is very important. What are we dealing with right now with remote work? But not only that, what does it also mean to use your personal cell phone while you're at work? Right? To use your personal cell phone while you're at work. And not only that, what does it also mean to force people into situations where they are compelled to perform, including under some sort of illegal lien or some sort of illegal obligation performance, without providing them with the appropriate facilities, including facilities that are bonded and insured to be able to perform their work. Okay, point 3 is important because this concerns a consideration yesterday of an opinion that was reviewed in connection with the Eastern District of California from, I believe, 1998 concerning Lloyd's of London and an allegation in connection with a criminal liability insurance policy. And what this says here is, it says, quote, the addition of a claim or prayer for interest enlarges the amount sought to be recovered, but adds no new transaction, occurrence, or fact. Now, this is very important because it discusses what happens when, including in subsequent appeals, one prays for recovery in connection with interest. This is also important because what is done with the items or that which is in dispute through the duration of the claim period. This is one of the reasons why appropriate evidence submissions process is so important. And a refusal to provide a safe, verified, and appropriately bonded evidence submissions process when there is still an appeal pending in connection with a proceeding, including if somebody tries to remand it to a civil proceeding, is so important. Okay, there's also a very interesting thing here. It says, quote, for these reasons, the plea of limitation should have been overruled even if the question had arisen prior to the enactment of Chapter 115, General Laws, Regular Session, 42nd Legislature. And then it talks about, here's the thing, look what this says, Vernon's Annotated Texas Civil Statute. That is a specific citation of Vernon's Annotated Texas Civil Statutes in an official opinion provided by the Supreme Court. You know what that means? That means that Vernon's specifically is identified as an official legal authority that also talks about a certain time frame and duration, including identifying that during the time frame wherein this proceeding was being appealed, there were changes to the general laws during the regular session, but that even despite there being changes, the plea should have occurred at some point earlier. In other words, no ex post facto or retroactive law. During the time frame wherein the appeal is still pending, the context for its evaluation is based upon the time when the original claim was made regarding the specific and original transactions. Now, if crimes are commenced in the course of the proceeding, that's one thing. But if one is still continuing the appeal on the original claim and in connection with what is compounded by the deferral of the final judgment, that's another. However, what does this also mean? Vernon's Annotated Texas Civil Statutes. This is the third instance where an official opinion by the Supreme Court specifically cites Vernon's. You know what that also means? It also means the pocket part regarding changes that happen on an annual or on a legislative session basis as the context within which to evaluate the legitimacy of and the specific legal context for the claim, regardless of how long one tries to delay the judgment or delivering on the judgment. It also specifically speaks to what was identified in that Lloyds of London claim yesterday, including the difference between something being lost and stolen and whether it's considered carelessness, including insofar as it may have been destroyed. As they follow up on, or as they come to a conclusion and consideration of point 3, this is an important matter. It talks about the context for considering recovery on quantum meru e. And it talks about services accepted by the defendant, but it also talks about how and in what manner those services were characterized. If you misrepresent what kind of services are being provided, including if you misrepresent what the intent was in the context of engaging the arrangement at the beginning, while you move forward on availing yourselves of the benefit of somebody else's work, including services in connection with a purchase or a sale, then there is a specific manner in which to consider what you would identify as the recovery versus what they would identify as the recovery. And so, intentionally attempting to libel someone or misrepresent their skills or qualifications, including the specific manner in which you engaged a relationship with them and what you had a reasonable expectation of expecting as their performance, versus attempting to try to acquire for yourself a benefit in connection with some other work or performance they had to do on their own, including outside of or independent of whatever would be considered a reasonable expectation of recovery in connection with an evaluation of quantum meru e in relationship to the benefit you received from their services. This is different if the contract is intentionally engaged at the onset to be illegal so as to try to make a justification for mischaracterizing what kind of services you expected to benefit from the person. In point 4, it says, quote, in determining what is reasonable under the circumstances of a given case, the end accomplished as well as the time and effort expended should be taken into consideration, end quote. It also says, quote, reasonable compensation due a broker is not always nor necessarily the usual and customary compensation, and vice versa, end quote. The issue submitted to the jury, therefore, was not the same as the ultimate fact issue, the reasonable value of the services which the law fixes as the measure of recovery. I contend this is very important, including and especially if somebody asks you to assist them with your professional in providing professional services or referral for professional services, and you refuse to do that. And so they are compelled to perform the work on their own. For you to later try to avail yourselves of the benefits of work you intentionally denied providing them and that they had to do on their own should be considered in connection with what is considered reasonable compensation as not always nor necessarily the usual and customary compensation. Now, point 5 is very important, and by the way, it's personal. The testimony of the witness York that Gay told him he was going to turn the property over to Colbert for sale should have been excluded as hearsay. Now, it discusses hearsay. Why was this not considered an exception to the hearsay rule? Because it does not appear that Gay's assertion was made within the scope of his authority. Again, however, who actually has the authority in this context? Now, this is important. It concludes by saying, on another trial, the plaintiff's petition should be amended to eliminate the count that seeks recovery on the contract, and the issue as to Gay's authority to employ Colbert should not be submitted. This is important in a literal context. Why? Because they're not disputing whether or not he has to be paid the fee in connection with being the bank being beneficiaries of the services connected to his performance. But in terms of recovery on the contract itself, it is saying that upon the third trial, the petition should be amended to eliminate that count. Well, that's very important. Where was and in what manner was that recovery held, used, or engaged in the context of the appeal? And then I contend the identification has to do with another witness being excluded for hearsay in connection with the communication between Gay and that witness regarding the assertion of his actual relationship to procuring a purchaser. However, what happened to the other witness of concern? And what we're talking about here is they've accepted that Gay was allowed to be considered a witness to Colbert, but that York is not allowed to be considered a witness to Gay. What about Ferguson? Ferguson had the specific phone call with and in connection with Gay and Gay's communications with Colbert. Why is York, who up until now has not been mentioned, identified and excluded as a witness by virtue of hearsay, but Gay and Ferguson and the identification of Colbert talking to Ferguson is not? So it's acknowledged that Colbert talked to Ferguson and had a reasonable expectation of believing that he was talking to Ferguson, except for the location that the call took place. This says nothing about the location of York at the time that York and Gay were discussing these matters, and it does not imply that that conversation happened over the phone, meaning York could confirm Gay's identity as much as Gay could confirm York's identity in a manner that is allowed to be implicit or excluded by virtue of the communication between Colbert and Ferguson over the phone. Where did York come from? And why was York excluded as hearsay? Because I contend, depending upon the actual location of York, that this hearsay, that this refusal to not admit it as an exception to the hearsay rule may not be applicable in the context of how the charges were presented in the consideration of verification of the identity of the authority of the individual involved. Now, it identifies that Colbert had talked to Riley, and that Riley had actually been shown the land by Colbert. That means that Colbert and Riley were both on the land together. Why was not the consideration of Riley as a witness in connection with Colbert's authority considered, and why instead was York mentioned with no prior mention of York? I contend that this is very important, and insofar as there would be another trial, that insofar as York may be excluded, Riley would not be.